Dear friends, Namaskar. In today's video, we will be discussing regarding the time limit either in initiation of the departmental action or in the conclusion of the departmental action, and we will also see as to whether there is a time limit for deciding the appeal in case the employee has been penalized with imposition of any of the penalties against which an appeal is provided. So, dear friends, uh, to make this subject easier to be understood, we would divide this into two fractions, that is, departmental action against a government servant who is still in service, and departmental action against a government servant who has retired. Now, we will start with the second. The departmental proceedings against the retired employee is certainly having a very strict timeline. In fact, the rule, that is CCS CCA rule, uh, does not apply to a retired employee in respect of holding departmental inquiry, but instead thereof, CCS pension rules will apply, and Rule 9 of CCS pension rule sets a limit, a very strict limit to be followed while proceeding against a employee who has retired from service. Say for example, we retired, somebody has retired on the 1st January 2023, and thereafter the employer wants to initiate a departmental inquiry. Then this rule 9 lays down that the incident or the misconduct which is subject matter of the departmental action must be within 4 preceding years. That means he cannot be held guilty or he cannot be proceeded against an act which he has committed, but that act has been committed beyond last immediately preceding 4 years. This means there is a time limit of 4 years to prosecute in departmental proceeding a government servant. So the example that I gave here, the 1st January 23 is the date of uh, he stood as a retired employee. Uh, that is 31st December 2022. Let us take this best example because normally people retire on the last day of month. So 31st December 2022 is the date of retirement. So we will go back. That is 21, 20 and 19. Therefore, if his act is committed in the year 18, that is going 4 preceding years, then law doesn't permit to initiate departmental inquiry against such employee. This means the legislature the lawmakers have expressed that the retired employees cannot be subjected to victimization or jeopardy of such departmental actions for a long time. And once 4 years have gone and departmental action was not initiated and the employee is retired, then it amounts to condoning the misconduct committed by him, and therefore the departmental action cannot be at all initiated. And if at all, if it is initiated, then the tribunals and the courts are bound to quash and set aside the entire departmental proceeding on this ground alone, because this is the very strict protection available to the retired employee. See, for example, someone has committed misconduct on the date of his retirement, that is 31st December 2023. Somebody is retiring, on the very same day he has committed certain thing which amounts to misconduct. From that day till next 4 year, that is 24, 25, 26 and 27. So 31st December 27 is the last day before which departmental action can be initiated. But once that date goes, then the very next day also the departmental inquiry against that fellow cannot be initiated. So this is the very strict law legal position in respect of departmental inquiries against the retired employees. However, now as far as the uh, employees who are still in service are concerned, there is no such strict provision of law as we have discussed under Rule 9 of CCS pension rule, and therefore we often see that the departmental inquiries are initiated for the acts or misconduct which might have been committed years earlier, years ago. Sometimes what has been committed 10 years ago also is dragged into the motion, and then on the basis of that inquiry is initiated. But the courts have applied the principle of Wednesbury, and courts have often come to the rescue of such employees who have been subjected to departmental proceeding in respect of very old actions committed by them. And therefore, uh, although rule does not specifically lay down any such time limit in initiation of the proceeding, yet on the basis of delay in initiating the inquiry proceeding, you can always go to the court or tribunal and challenge the same, because there are judgments holding that the delay in initiation of the inquiry proceeding is nothing but violation of principles of natural justice. Because if something has been done by me before 10 years ago, today if I am called to defend myself in respect of that act, my memory fades and I may not be in a position to defend it. Therefore, this amounts to denial of the fair opportunity of defending myself, and therefore the delay initiation has been accepted as a good ground by the courts or tribunals to interfere into such matters. Now, this is the case where delay is in initiation of the inquiry. Now, another kind of delay, the inquiry is initiated and there is no delay in initiation, but then there is delay in conclusion. Say, for example, inquiry is initiated today and it is going on for the years together, 5 years, 6 years, 10 years, something like that. This happens. We have seen in many such cases that inquiries go on for years together. So courts have also accepted the delay in conclusion to be a good ground to interfere. And in this regard, there is a recent judgment of Supreme Court, Premnath Bali versus Delhi High Court, I think. In this case, the Supreme Court has observed that the inquiry must be concluded within the period of 6 months. And for any reasons, if it is not possible to conclude within 6 months, then it can be further extended for further 6 months. But in any case, it must be concluded within a year. This is the timeline that has been actually said by the Supreme Court. But in fact, this is also not specifically adhered to by the employers. And when any employee goes to the court, that inquiry is initiated and more than 1 year has gone, and on this ground this inquiry must be held illegal, then also it is very surprising to see that courts do not set aside or quash the entire inquiry on this ground, because Supreme Court has said that the inquiry must be concluded within 6 months, but Supreme Court did not say if it is not followed whether the inquiry should be quashed and set aside. So it depends on case to case, judges and the nature of allegations. The delay can be accepted as a good ground, because in many serious cases, complicated cases where voluminous record pertaining to the misconduct causing huge misappropriation of huge public revenue or something like that is involved, certainly courts will not accept the delay as a ground to interfere. So it depends on the allegation. Sometimes very normal, very petty allegations are made out, and the inquiry goes on and goes on. Then in such cases, courts may interfere. If the normal and petty charges are also being inquired into for years together, then it should not be allowed because it amounts to harassing the employee concerned, and it also affects his reputation as a whole. Because people in society often gossip that he must have done something, therefore he is facing inquiry, etc. So this also violates Article 21 in that respect. Therefore, courts interfere. Now, after the inquiry is over, for example, if at all it results into imposition of penalties, then certainly the rules provide the appeal against that, whether it is a major penalty or the minor penalty. The rules also provide appellate authority and also the procedure to be followed by the appellate authority. And the rules also lay down the uh, time limit for the appellate authority to decide the appeal. However, despite this, it is very rarely seen that appeals are disposed of within the time limit set under the rule. And there also appellate authority takes years together in some matters, and sometimes uh, more months than what has been stated in the rules. Generally, it depends upon the rule position. The rules under which inquiry is initiated will say with regard to the time for the appellate authority. Similar would be the case in case where penalty of major penalty or minor penalty is also subject to revision, because uh, revisional powers are also very important. Sometimes what appellate authority has decided can be overruled in the revision by the revisional authority. Therefore, revision is also very effective remedy. And after failing all these things, certainly one can go to the tribunal, that is Central Administrative Tribunal and the Maharashtra Administrative Tribunal. There is a time limit, that is 1 year from the date of cause of action, and here cause of action would actually start when you exhausted the last remedy, that is you exhausted appeal, you exhausted revision, and revisional authority has given a decision. So from that day, your limitation to go to court would start, that is 1 year. So these are the time lines with regard to departmental actions and their aspect like appeal, revision, and going to court, etc. So this is a very short video on today's topic. Don't forget to subscribe and like and also share. धन्यवाद.